In Georgia, there are a few key aspects of property tax law that define the rights of the property owner. These fall under Senate Bill 177, Act 431. It's a law that went into effect in 1999. The law offers some important clarifying factors about taxes in the state. One area of importance is the prevention it provides for indirect tax increases. Specifically, those indirect tax increases that occur as a result of inflation within a county to the existing property values are prevented. The law also clarifies the property owner's right to object and then appeal an increase that is made by the taxing authority based on the proposed value of the property. It sounds a bit confusing, but keep going here. First, consider the provision of OCGA 48-5-32.1. This rule was put in place by the Revenue Commissioner. These regulations govern a number of aspects of the taxpayer's rights. These apply specifically to the rollback of mileage rates that can occur when the value increases after an assessment of the property. Let's clarify some of the key points. As noted, the first is the prevention of indirect tax increases. Annually, the County Tax Digest has two specific types of value increases possible. These occur as a result of inflation, as well as increases in value due to the improvement of properties or new properties. In situations where the mileage rate is rolled back each year to offset any inflation increases, this would be done by the taxing authority. When the taxing authority doesn't roll back the mileage rate, but inflation increases the value of the home, the authority is then required to notify the public that there is an increase in the taxes they have to pay. For example, the community sees inflation grow in the previous year. If the taxing authority recognizes this and adjusts how much is collected to meet the previous goals of the tax levy, there's nothing else to do. But if the taxing authority, which can include a county, school board, or city, or whatever other organization is levying the tax, does not do this, then they must let the public know their taxes are increasing. Under Georgia law, the total digest of taxable property is prepared with an eye on inflation. The law requires a rollback of the mileage rate when inflation occurs. The new figure should produce the same total revenue for the taxing authority, based on what would have been raised had no inflation occurred. Let's say the county decides not to roll back the rate. When this happens, they must hold 3 public hearings. They must issue a press release. And they must place notices of the increase in the local newspapers. Each of these news reports must provide information on why and how the tax was managed. Now, the second component of the Georgia Taxpayer Bill of Rights focuses on the enhanced taxpayer rights when they appeal property increases. The law significantly improves the taxpayer's ability to appeal the decision of increased property values from prior years. First, when there is a change, the taxing authority must give an assessment notice to the property owner. It needs to communicate the steps the taxpayer can take to learn more about the value change or to appeal the decision. When the value grows by more than 15%, the taxing authority has to provide even more information, including a full breakdown of reasoning. Then, if a property owner goes through the appeals process because they don't agree with the new assessed value, the assessor must provide reasons for rejecting the appeal. And the assessor cannot make additions to these reasons later on if the appeal process continues. Another important change is who is responsible for proving the value of the property. Like in a criminal case, the burden of proof lies on the shoulders of the government, or, in this case, the assessor adjusting the value of the taxpayer's property. They must show by a preponderance of evidence that the change in value is valid. In fact, this responsibility to provide evidence to support their claim must continue through all stages of the appeals process, even if the case lands in the hands of the state's superior court. The law also provides the taxpayer with the ability to change the hearing and superior court proceedings time just once, should they need to do so. The law even made it possible for taxpayers to request a time for a hearing that is as early as 8 a.m. or as late as 7 p.m. The goal is to make it possible for residents to be able to manage the process of appeals. Another key aspect of this Bill of Rights clarifies the court costs and fees associated with the appeal process. The law makes it possible for the property owner to recover these costs, including attorney fees if the property owner's appeal is validated. More specifically, if the court finds that the value is 85% or less of what the Board of Equalization determines. The law makes it possible for the property owner to record conversations too. For example, the property owner can record conversations with the appraiser or the assessing office and use these recordings in the appeals process. Finally, and this may be something agents should look into to be able to provide for their questioning buyers, the law makes it a requirement for the tax commissioner to provide a full brochure to the public that outlines all of the property tax laws and the procedures for them. It includes information about exemptions and preferential assessment programs too. All of this data gives the taxpayer a bit more leverage in controlling their tax assessments.